are you? You applicant?
My lord, in one of the petitioners, in both the petitioners' respective complainants in those FIRs.
Is you applicant in the complaint? Is that behalf of the state? A long indication was given to the court that charge sheet had not been filed, but in reality, the charge sheet was filed on the day
2023.
on the day prior to the date on which this court had.
My lord, if I may make a submission, my lord, at the relevant time the charge sheet was never filed. Even today, it was only filed for the first accused, my lord, who was not a party here.
I only clarify clarify.
Talk together, it's very difficult to get clarified.
I apologize, my lord. I just want to
interrupt your lordships. I appear for the state that at that time also the charge sheet was filed. However, the further investigation against one of the applicants was pending.
So your statement is wrong. You have come with the wrong facts before the court.
my lords, there are two FIRs.
Investigation is not cooperating.
My lord, it's mentioned in the charge sheet itself. If I may point out the relevant page numbers, my lord. And this is only a charge sheet in one of the FIRs.
Main point on which the applicant faces is that though at the material point of time, charge sheet had been filed against both
The first accused in the FIR, my lord,
the first accused
who was not a party here.
in the FIR, others were not filed.
Please, my lord.
The names figure in the charge sheet.
Accused persons,
The charge that I've given the
charge sheet had not been filed at that point of time. Subsequently, admitted position is that charge sheet has been submitted. So, we do not find any conduct attributable to the bail petition, the petitioners seeking bail, which would warrant cancelling of the order of the bail. So, the discrepancy of the question of heading of charge sheet does not materially affect the position so far as grant of anticipatory bail.
Yes, 100%.
Grant of anticipatory bail is concerned. Hence, we dismiss the notification.
Lordships may only direct that let them cooperate because the further investigation is still on.
The petitioners seeking bail should, the petitioners who have obtained bail should cooperate with the investigating agency.
as an
Okay.
Yes.
And seeking a relief, my lord, in furtherance of the lordship's judgment, my lord, sir.
Let me tell you, lordship, I have cleared for the cleared candidates. We are also in the process of filing an application.
The fifth bite of the cherry, you have dismissed five so far. Eighth day,
In the
Let us
Supreme
hear,
Court, we don't argue like this, no. Number one.
you do.
Number two, sorry, that's what you do. Yes,
here,
yes,
the solicitor,
yes,
hear you and then review.
yes. But just one point I want to make. So far as Madhya Pradesh is concerned, in Bihar also this issue arose. And Bihar High Court has passed a judgment on 6 December 23, saying that DED is not eligible. And about 20,000 people are going to lose their jobs. That SLP is in the process of being filed. One has been filed.
But I have no problem with your lordship's judgment.
Let's say that whether it's
Prospective or retrospective, that's all. And my lord, if it is not prospective, okay, a minute, if it is not prospective, lots of people are
If
affected.
you want us to clarify, those who have already got appointment,
They will not be, yes.
appointment will start.
But page 61, not page
correction, appointment.
yes, the one. Yes, my lord,
Correct.
Yes, yes. And this is page 61. My lord said, let me say this contingency. My lord, page 61, your lordship were pleased to say.
Then why you trouble still?
No, no, this is for Rajasthan, not I am Madhya Pradesh. I was not a party before your lordship. My lord.
So this would cover all the states.
Yes, my lord, that it will be prospective in operation. That's all. Having made the above determination, we all the same are also of the considered opinion that state of Rajasthan before your lordship.
But till then it was a law.
Yes,
We have followed it. That's what you're saying.
and we followed it, my lord, because that was the law. That's all.
I've heard that the council appealing for the parties in NA number 4303 of 2024.
We are open to this.
But those who are appointed, you want to.
Your lordship, now we'll all get, if these people are, who's ineligible, your lordship, I remember very clearly Justice Julia saying last time, that we are looking at the interests of the children. It's not about each of us having a 19(1)(g) right, fighting against each other. It's not a service matter.
These are all
So, I'm sorry, I was told that this is not the practice of the court, so, let's just proceed. Now it's my turn. Now, yeah, Mr. Patola was a friend.
I know everything.
Subject to that discussion. It can be confined, it can be those candidates who have been appointed.
Correct.
That's all.
Subject to.
My lords, can we make a submission on that after my learning?
No, you go ahead.
My lords, there is one aspect that I would request my lords to consider. This was a central government notification under the NCTE Act of 2018. On 25th of November 2021, Rajasthan High Court struck it down. It was quashed. Once the central government notification stood quashed, which applied to states across the country, it stood quashed for everyone. When the matter was carried to my lord, yes, my lord, so I just,
This proposition.
my lords, I can satisfy you on that because
There have been many judgments where.
no, my lords, I will be able to satisfy my lords on this aspect because the once is a central legislation and it has a uniform application, then once it is struck down, it's struck down across board, I'll be able to satisfy that. Then, my lords, when the matter was carried to this court, my lord said, did not stay the judgment of the High Court, but said subject to the outcome. Eventually, my lords upheld the quashing of that particular NCTE notification. Now, so far as Madhya Pradesh is concerned, there are two dates which are very important. My lords, this was quashed on 25th November 2021. Now, the notification that was issued by the Madhya Pradesh government for the purpose of holding the examination was in 2022. when the notification already stood quashed. The writ petition in Madhya Pradesh High Court
He's
came
in
filed.
Rajasthan.
My lords,
It's not concerned.
my lords,
We're all Madhya Pradesh. We're all Madhya Pradesh.
now please,
I don't have any.
as a courtesy to us also, we may not have the panel listing on the other side. Now, to my lords, there's one more submission which is very important.
As regards Madhya Pradesh, there is
Yeah.
application.
This is the application.
This is the application.
This
That's our application, Madam.
Oh my lord, please appreciate one thing, and this must be pointed out.
I don't think
My
he has an application.
Mr. Bella, for a minute.
I have an application notice.
One
You
minute.
may address that. I
11
have an application.
August 2023, my lords finally upheld the Rajasthan High Court. The appointments in Madhya Pradesh carried on even after my lord's judgment. Now, I do not think there is any justification once my lords had quashed, and today to turn up and say, we have given appointment to 11,000.
Appointments which are after the judgment will go.
Correct.
My lords, Rajasthan High Court, I will make good that law.
No,
I will make good.
our.
My lords, please appreciate.
I have to.
My lords, can I, please, my lords.
We are with you. As far as diploma is a qualification, BEd is not a qualification. But this is a huge problem.
So let's not.
There's so much of unemployment in this country. After somebody has got a job.
There is.
Don't,
My lords, let me respond to that. Let me,
11,000 of us don't have jobs.
my lords,
No, we won't. It's not.
Quality of your training.
But these people
my
have,
lords, I want to answer.
these people have done the course also, but
They are properly trained.
Yes, I know that of course.
Now we ask them.
My lord, may I answer this on both of the aspects, please? Number one, so far as the unemployment aspect is concerned. My lords, it's like one shoe or the other, because we are also as many numbers who are today qualified, who are eligible, who were entitled to these particular jobs and have been kept out. So if we talk about 11,000 coming out, there is equally 11,000, those numbers will get an employment. So it is not a case of not suiting one or, giving away those employments won't be there, but there are people who are waiting. Number two, my lord said that we will get the jobs now. We will not. And may I explain why it will not happen? My lords, these were qualifications and jobs for a particular year. We have not been allowed into this. As we go forward, there are other batches which are ready. So therefore, the zone of consideration of the eligible candidates increases far more. So those of us who will go out now from DED will now go into a competition with large more. But so far as DED is concerned, my lord, we can come only in that primary school, only. We have these opportunities widely, much larger. So my lords, while we get deprived of these jobs and they have many other opportunities, and particularly in light of the judgment, and I would say at least from 2021, when my lords that paragraph at page number 61, let me put that in a perspective how my lords had put it. My lord said that until there was a determination by Rajasthan High Court, because what happened when the notification came from NCTE, Rajasthan state did not follow the notification. It non-suited the BEd and said only DED. My lords, what happened then is the High Court and my lords have observed categorically, state could not have done it by itself because there is an NCTE notification which is binding on the state. So state by itself could not have removed the BEd candidate till such time as the court watched it. And that is right, my lords, it's absolutely correct. Today what happens is that NCTE notification stood quashed on 25th of November 2021. That was a central notification. Once it stood quashed on 25th November 2021, exams held in advertisements issued thereafter, where BEd were allowed to participate and given an employment, my lords, in my respectful submission, were completely unqualified. It couldn't have been done. But what I request my lords to consider is this, that the state so brazenly, notwithstanding the fact that they were a victim, dismissing such applications or from different states. Out of that, 2 applications and 1 application in Arnab Ghosh, all 3 of them had prayer for prospective overruling. So expressly, and my lords dismissed those. I submit that once my lords have already taken
Applications were not made,
my lords,
wanted to be appointed.
courtesy for my learned colleague on the other side, yes, the compilation and the overruling. Here, my lords.
But only one interjection with your lordship's permission. Your lordship would see the wash notification say
I haven't finished.
that on your limit.
We haven't yet finished, you can take your time.
You know what I'm going to
My
say.
lords have asked us.
Yeah, minute, Lord, the wash notification says 2 qualifications permissible, diploma and BA. They also gave, I don't know who are ABCD, but diploma holders also participated. They could not make it, they were not successful. Thereafter, your lordships were pleased to not say that BA part is not legal.
My lords, as of today, there is no, my lords, that's a
They
compilation.
participated, did not.
My lords, first of
succeed,
all, let
and
me.
now they want to house
And one line
My lords,
of
can I
information.
show you?
Every state has its own rule.
Again, whatever, DNA, whatever name it's called, there is this TET also. So the figures show that's quite many of the BA qualified in proportion are the ones who are qualified TET than them. I don't know how it is happening. Yes. Or even if it is not happening, then many of the BA qualified have qualified TET, diplomas have not. So they have gone in your pocket. That is all.
They are overqualified, maybe.
Not overqualified. No,
They're not
you are not qualified.
No training at all, sir.
You are not overqualified.
6 months training.
You are not qualified. Not qualified at all. They are qualified.
Yeah.
But when you are made qualified, both of you had to undergo this step called TET. Some of you qualified, they did not think about it. That's all.
That
My lords, in our case, we are qualified.
TET was a pre-qualification for
We
application.
are TET and we are DL, my lord, we are all
For
qualified.
application.
Now, my lords, let me show you the one application. My lords, we are,
Your lordship, see page, the para 30.
my lords, can I show the
Of
orders
of your
for
minute, page
prospective
38,
overruling has been rejected?
page 38, my lord.
Perspective of the matter which we are hearing.
My lords,
First, let us hear that.
yes, my lords, can I just show the prospective overruling having been already rejected by
My
my
application,
with
I ask
express
you, my lord.
players?
This is
My lords, I have handed this compilation of orders which have been passed by my lords.
NA number 4303 of.
Yes, my lords, that's the one, which is,
This
Yeah.
pertains to.
So that is state of Madhya Pradesh application
Okay.
filed by me, only saying, my lord, that there is, please apply this prospectively. Lord, if your lordship,
my lords, can I?
Madhya Pradesh government, I have moved an application for Madhya Pradesh government, saying that those who have been appointed prior to your lordship's judgment may not be affected by the judgment and therefore apply the judgment prospectively. So Lord, your lordship's judgment at para 30,
Can I
I'll
finish
just-
this part? Can I finish on the
Only
prospective?
a minute is exactly told.
Let us see what you want actually.
Lord, your lordships were pleased to record this, Lord, para 30 of the judgment. The sequence of events which are now well established by the documents which were placed before Rajasthan High Court and before this court make it clear that the decision to include DED as a qualification was apparently triggered by a letter of Commissioner KVS, who made a requested that since the primary classes of central schools sufficient number of trained diploma holders are not available, they may be permitted to appoint DED. So they are in demand, they'll get the job, what, how do we?
Rajasthan, yeah.
That's where,
State to state.
Yes,
So what is that too many?
So there are 5 other states where we are in the process of.
And not even a party, my lords, I not hear us.
the central agency, KVS, I'm sorry, we are.
That to Madhya Pradesh.
No, KVS has given, as it appears, right to MCT for all states. That this is the problem, therefore include BA. Be that as it may, it's 2 years down the line, they must have changed their position, they must have taken loans, they have taken loans, they would not get any benefit, they are qualified, they will he appointed.
The prime officer means that those who were appointed before the judgment was verified, yes, ought to be, their employment ought to be retained.
Unless they were protected by a High Court's order which said subject to outcome of what happens here. Unless, because otherwise, let me just
From giving prospectivity.
Mr. Mehta will run this court now. I mean, every time I say open my mouth, he has to interrupt.
But I do not know whether, I sometimes
He can't
wonder
cover anything.
whether he is inherently rude or he has taken some course.
Learn from you.
The entire exercise seems to have undergone some special training.
They just submit one thing, there is already a writ petition, when we had got.
We have to ask you.
I'm sorry. I'm not.
We are only examining.
We are just.
Madhya Pradesh.
We are just reacting on the Madhya Pradesh question. Yeah. Yes, there was, which has not been placed by them, which is not referred to in the advertisement either. So we have copies of it.
My notes, it's in that compilation.
No, it's not.
7.
We are giving it
Let
separate.
them file a reply. Let them file a reply. Proper reply. We can't.
No, they should have placed it, is all I'm saying. They should have placed it. It's the state. It's the government of Madhya Pradesh who has appeared through Assistant Solicitor General and Government Advocate. Now, if I may just read this, and please note a few dates. This is very relevant. The Rajasthan High Court's judgment is dated 25th November 2021. So, with effect from 25th November 2021, following the Kusum Ingots principle, which is well laid out, once a central notification is struck down, it stands struck down for everywhere in the country. There's no exception to it. Yes, but I'm just telling you now, it's 25th November 2021. Now, just see that they are represented, Government Advocate, Assistant Solicitor General, they're all represented. Challenge here, this is the fourth para, is to the virus of the eligibility condition for direct recruitment for the post of primary teacher to the extent it prescribes BEd degree to be one of the essential qualifications of the notification of similar nature. Yes, writ petitions are pending. Now they have told the court, and that is in the compilation added up, it's the last order. They have told the court there that our applications are pending here, they have to be taken up.
We cannot pass any order.
That is exactly.
They are released claims in the application.
Yes.
That our judgment should be prospective, has to be prospective.
Yes.
If we hold so,
Yes.
then let it be.
So allow me to make a submission on that. If you have already rejected this prayer, you have already rejected this prayer 4 times.
We may consider
This order, this is the fact, that the same notification, the 2018 NPTE notification, and the 2 advertisements pursuant thereto are challenged in this. Now, when this came up for the first time, it came up after the Rajasthan High Court judgment, which quashed the NCT notification. So the primary argument that your lordship are being faced with is this: what is the effect of the Rajasthan High Court judgment on all the other states? Which Rajasthan High Court judgment, to the extent that it quashed the NCT notification, has been sustained by this court. So the Rajasthan High Court judgment, which merges, is dated 25th November 2021. Now that struck down a central notification, therefore it's binding everywhere, which is why when the matter was taken up, Devesh's matter was taken up by your lordship, it notes the fact that apart from Rajasthan, UP,
Correct.
yes,
Whatever you are now, this argument is very appealing.
I have,
But
yes, I agree. So you dealt with it. Correct. Correct. So, correct. So now the date for reckoning is the first question. No, I'm sorry. Correct. Yes. After 25th November 21. Correct. So after 25th November 21, anybody who issued advertisements were doing so at their peril, which is why 3 other states apart from Rajasthan came to this court. Your lordships had them all as parties and said, we're taking the facts of Rajasthan, we'll take a look at Rajasthan and give our judgment based on Rajasthan. Secondly, this is not the first application. This is not the first special bench of your lordship disturbing yourself at 2 o'clock. We've been before you before. No. So the question is, those clarification applications, what were the prayers there and what your lordship said there? They asked for the same thing. They said prospective. They said allow it to be prospective. Your lordship said no, nothing doing. In one case it was dismissed. In 2 cases it was withdrawn. In the 4th case, which is Bihar, your lordship particularly said, while Bihar is not a party before us in these proceedings, we believe that the judgment in Devesh Sharma will be fully implemented by the state of Bihar without passing that direction, and said that all consequential advertisements, notifications, etc., after 2018, not 23, not even 21, from 2018, all of them would go. That's what your lordship directed, which is why now you have a Bihar High Court judgment. And if your lordship were to disturb this, the Bihar High Court judgment follows Devesh Sharma. Against which, if another date is given, apart from this one application of Madhya Pradesh, you'll find an SLP of Bihar, you'll find other applications, and Devesh Sharma will be opened up all over again.
Your lordship, a wrong statement has been
Now,
made with
allow me-
the MA that was filed. It was not on behalf of appointed candidates.
That's not on, there are 5 applications. I don't know which one this is particular. Now, if your lordship will just take up that compilation. This is to show you that fully aware of the Supreme Court's interim order that your lordship passed in the Rajasthan matter. Madhya Pradesh said that all appointments would be the subject matter of the final order of the apex court. So now, the advertisements that they issued should have told these new candidates coming in ineligible that look, we have made this statement before the High Court, it's going to be subject matter of all proceedings. It's not a simple matter of saying that they were caught unawares. Nobody was caught unawares. Everybody knew. All the other states, all the other applicants who were BEd candidates had intervened before this court, made argument, many of them by counsel present today. Now see the advertisement dates of Madhya Pradesh, which is relevant.
After this.
2 advertisements.
Only one, my learned friend has something to say.
That's not understanding.
Yes.
The 2 advertisements which were issued by Madhya Pradesh on 19th October 2022
16th November.
and 16th November 2022.
After this order.
This is both after the order of the judgment of the Rajasthan High Court, which was not stayed by this court, and the High Court's interim order in Madhya Pradesh. Interestingly, what the Rajasthan High Court did was to quash the notification. Therefore, BEd couldn't take part. When they came to your lordships in SLP, the BEd candidates as well as the state, your lordships did not stay the judgment and said that all appointments made pursuant to the Rajasthan High Court judgment is subject to the outcome of this. That means without BEd candidates, appointments were made, and therefore it would be subject matter or subject to the outcome of Devesh. So if Devesh finally decided to reverse the Rajasthan judgment, then the BEd candidates would get their rights for the first time. That is what happened in Rajasthan. Same has to follow suit for all the states, and that's what your lordships have said. Now, I've shown your lordship the interim order, which makes it clear that it will be subject to the outcome. Outcome has come now. Those who have suffered this order can't say, sorry, ignore that order completely. I'm not even placing it before your lordship. Let the clock start starting from this order. Yeah.
My lord, same has happened in Calcutta High Court as well.
But I just want to tell your lordships two things. Easily come by.
Possible to create a bridge for.
It's there. It's there. We have to do it. There is already.
So format of a bridge goes today.
No, let me tell your lordships two things. Just two things.
Something deficient, definitely on behalf of the government, we are ready to undertake. There is absolutely no problem.
Second, how many vacancies are there countrywide right now in this institution, the primary?
Let me state wise.
Let me tell your lordships two things. Firstly, after the Rajasthan judgment, your lordship recollects, we had relied on it. The Himachal High Court on 26 November 2021 took a diametrically opposite view, did not follow Rajasthan, said 28th October notification is valid and needs to be followed. So,
It is not, they may not be knowing about Rajasthan.
no, it is
Now, what,
That was the 25th, that was the 26th.
my lord, what my lord prevails is your lordship. My lord, divergent views do not matter.
And Calcutta High Court division bench also took the view that notwithstanding Rajasthan, so the notification is valid and in the jurisdiction of Calcutta, that notification was relied upon and appointments made. So really the cutoff, really that falls on the day when your lordships decided is point number one. Point number two, they are not part of this compilation of judgments they are relying on.
Who are they? I mean, they're not even parties here.
So far as we have been able to learn,
It's not even Madhya Pradesh bar. It's one of the India for one application.
appointees of Madhya Pradesh. And I am also appealing for the appointees of Bihar, whose SLP is in the pipeline. And you have already been appointed. Yes.
SLP, you are checking the Bihar's order.
Yes, where are coming?
As a council, he is in Bihar also. Clients are different, but
Yes, I am exactly. I am not Dinesh, I am Dinesh. So I am only saying, Lord, supporting the applicants, saying it should be prospective. Because these are who have gone really.
your lordship may consider, my lord, only a minute.
Saying respective to not solve the problem, we are trying to give a comprehensive term.
Yes.
My lord, only a minute. My lord, your lordships may consider saying, those who are appointed after the judgment are not entitled.
Exactly. So any.
Unless your lordship says prospect. Not. Yes.
Correct.
And the courses they will have to undergo. The bridge course they will have to undergo.
Those my lord, there is no mention.
They are the actual effects.
May I just supplement only one thing?
I must conclude.
1 lakh and the jobs are only 11,500 odd. And we are qualified, and they are occupying them, and they can go to secondary and whatever other, we can't.
That is exactly the point, madam.
I do not understand.
PA can go to secondary.
No bridge course, my lords, we have got in RTI, there is no bridge course, there is not even one BEd candidate. In RTI, we have that information. Come back.
Actually, what is happening? Now this BEd, this is what it should go. Now there should be a one course of 4 years or 5 years, which can be equipped.
Everything included, all included, yes. Lord, instead of 1 week, we have it 2 weeks, not because this.
Take it up on first.
Yes.
But the high courts can proceed, I guess, because they are going to get over.
High court should not, Lord, high court.
There is no
Lord, that one, there will be SLP.
Eventually, it shouldn't be a situation where Devesh Sharma comes once again on a
There
reading.
is one vital thing, Lordship, there is already a writ petition, Lordship, where we have thought that the all appointments made after 28/6/2018 should be quashed. And Lordship have issued notice in that, Lord, that I have annexed the order not in my IA, 54821.
From that year,
The union is not a party. I take, I request Madhya Pradesh, I am for the Madhya Pradesh.
In Devesh, your notification.
Anyway, I am here, I can always request concerned department.
yeah, like we spoke about, like we spoke on 2 points. The first is how we can primary schools are still there across all the states and Indian territories. And I learned, secondly, if there is a breach course operating through which the BEd candidates can train themselves up to make their qualification at par with BEd candidates.
Or, yes, or you can get this course done immediately from this open university.
The Lordship may say appointed BEd candidate. I am saying something against me, not appointed BEd candidate.
No, I'm sorry, Manoj. It appears that that's been struck down by this court.
That was struck down.
Anyway,
We'll place it on record, we'll place it.
In the meanwhile, may I ask what will be done for us? Because we've been left out, we have succeeded in every single court, and at the end we are being told that we won't get it.
You failed in the competition.
No, I didn't fail anyway. I didn't fail. You are thrown out of the Supreme Court.
Well, hearing both of them are not decided, already decided, but they are not paid. Like,
Talk like this,
Only
everyone.
Mr. Mehta. I must admit, it's only Mr. Mehta because he has a unique talent.
If Lordship conducts the voting, it will be 99 versus 1.
Yes, you'll be the one. Yes. Your Lordships, if your Lordships are looking,
Therefore, I am able to laugh, my lord.
if your Lordships are looking for constructive, I'm sure the learned SC will come back, whatever the numbers are. But eventually, it shouldn't be a situation.
No.
When I'm on my feet, I'm sure I shouldn't be interrupted.
So there is a writ.
But your Lordship should not be interrupted, should not interrupt it. But now he has his zone of consideration expanded to your Lordship.
I think the audience equitably.
No, he says your Lordship should not interrupt when he is on stage.
Mr.
I have 40 times without.
That's all you know.
Because they are the person who can come into it.
We have created this mess.
What's in your son? Normal devices running project. The last portion is
Calcutta High Court, in view of Ramsharan Lauria's judgment, did not choose to follow Rajasthan. That's the
Which year is Ramsharan Lauria's?
is 20. Though there was this was an auxiliary issue. Main issue.
Sir, let us take your lordship's word will be the final word.
Right, that's right.
All high courts taking different contrary views have no relevance.
Created all this mess. In your meetings, your officers said that DED is a higher qualification
The
than.
minister said sitting in his chamber without consulting NCT. That is
But
In any case, all that is now water under the bridge. Your lordships have given a final verdict. I would agree with this application to say any appointment made before your lordship's final word should be protected is the request to the court, because there was a lot of fluidity in the whole law until that point of time. And we are fighting in a court of law. These are small teachers. Somebody has given up jobs. Somebody's got married on the point that you have got a job.
What happens to us? I don't understand. What happens to us?
So let us not go into it. If need be, we will assist your lordship. No.
Yes.
And my lord, on the lighter side, on this, my lord, if your lordship like to have a poll here, but I will be on my proposition.
Out of fear. The first step is you don't have any constitution based to address.
Right.
One last request, again, one last request, because I am in the state of duty that in that petition, lordships have issued notice. That will affect not, because
Is it before us? It's
before the lordship, before the lordship. Decided by your lordship, your honorable justice.
Not the special bench, but before justice court.
Okay, is it coming in one of these days?
Yes, Lord, it is coming in within a week.
Find that.
On lordship, I will give a number to the court martial if they made, because that has not been, that will affect in any case, Lord, because there are certain.
Bench combination has to really.
Because that also relies upon judgment of Devesh Kumar, Lord.
Okay.
Yes. So not.
When the matter is called on, you remind us.
Because it has not been, every time it gets deleted, that is why I am saying.
That cannot be.
I will get the number to the court martial, Lord, right now.
I don't.
That maybe that, because.
I don't think.
Oh, right.
I think it will be separate.